Hi, I'm attorney Gregory Dell, and I'm here with attorney Rachel Alters. And today we're going to discuss why your disability insurance lawyer must understand your disabling condition or conditions. And Rachel, this is super important because we always say that medical support is like 90% of a disability claim in terms of what it takes to get approved. But we've handled thousands of disability claims and seen almost every single type of medical condition. But there's a distinction, Rachel, between a medical documentation of a form and a legal documentation in the medical records. And I want people to understand why that's so important when it comes time to present the disability claim. So, why is it that you need to present the claim in such a supportive manner for a claimant that a doctor necessarily wouldn't be able to do on their own?
Well, Greg, one of the most important things in a disability claim is presenting the claim to the insurance carrier, both in a medical and legal fashion, so that the claim gets approved. So what we do, and it's really important that the attorney understands, number one, the medical conditions that can present themselves that can be disabling. And there's so many. I mean, there's cognitive issues, there's people who have severe physical disabilities such as back issues, there's Parkinson's, MS, there's a whole gamut of disabling conditions that can pull a person out of work. So it's really important that the lawyer that represents the client understands, number one, what all of those conditions are and what the symptoms are, what all of the testing that goes along with those disabilities that are necessary to show the insurance carrier that yes, this condition is disabling. So it's really important for the lawyer to understand if a client has Parkinson's disease, that there are physical and neurological issues that come along with that disease, and there's specific testing that's going to need to be ordered. Whether or not the doctor has thought of that in advance or not, it's something that their lawyer can suggest to the physicians and say, hey, we think that a neuropsychological evaluation needs to be done on this claimant in order to determine the cognitive deficits that the claimant may have that can prevent them from being able to work. And a lot of doctors really aren't trained to create medical records and order testing that's going to be able to get the client approved for their disability benefits. The carrier is looking for not only just medical records that say, yes, this claimant is sick, yeah, but they say, well, anybody can work with disabilities. People can work with MS, people can go to work every day with Parkinson's. It just depends on how extreme the condition is. And it's our job to know, how to instruct and guide the doctors into documenting the medical records properly, ordering the right tests, so that the claimant has as good of a possible chance to get approved as they can.
And as you know, on our website, we have specific pages for all the disabling conditions, not all of them, but for clearly, more than 50 of them. And a lot of them are categories and have subcategories within a particular diagnosis. So we try to kind of superficially cover all of those things and provide information about our experience in working with people with those specific medical conditions. But I know that every time both of us represent a client and we talk about their disabling condition, we right away know in our minds, okay, this is what the disability carrier is going to want to see. This is what they're going to claim is missing. And we can immediately identify, what's in your records after we review them, what's not in the records, and get ahead of the disability insurance company so that they don't say you don't have this. The flip side of that, Rachel, is whenever we do appeals, which is after a claim has been denied, in terms of looking at the reviews that have been done by the disability insurance company, whether it's their in-house doctors or their outside doctors, and really calling them out on what I often find are their misrepresentations about what's not in the records. Can you speak to that, about how often you read a denial letter or read a medical review and they're talking about, oh, you don't have evidence of this or that, but really there's no such thing as that particular objective evidence, and they're really just trying to manipulate the claimant into thinking that they're never going to be able to get their claim approved?
Absolutely. It happens all the time. I can't tell you how many times I get an appeal. I get a denial letter that requires the client to appeal, and it's claiming that, oh, we did this peer review, and our doctor, who is a medical expert, has reviewed the claimant's medical records in detail and disagrees with the claimant's doctors who claim that they're disabled due to, let's say, it's fibromyalgia. So when a claimant has fibromyalgia, it's a medical condition and it's serious. People who have fibromyalgia not only have pain throughout their body all day long, they have cognitive issues, they have severe fatigue, but the problem with fibromyalgia is it's subjective. So there isn't an objective test that one can take to say, yes, you have fibromyalgia, this is how severe it is, this is how severe your pain is. And oftentimes these denial letters will say, well, our peer review physician has reviewed the medical records, and yes, the rheumatologist may claim that you have fibromyalgia, which we're not denying, but we don't see any evidence that you are in severe pain, that you have all these issues, that you're not able to work, that you're fatigued. Well, there is no objective test that claims that you can, number one, prove that somebody has fibromyalgia, because it's a diagnosis of exclusion. So the way fibromyalgia is diagnosed is the doctor will basically test for everything other than fibromyalgia, and then if you don't have all those other issues, then yes, fibromyalgia is likely the culprit, and then they could do some trigger point testing and basically go on what the client's subjective complaints are. So oftentimes they will cherry pick the records also and just look at what they claim to be what's important in the medical records. But they will say, yes, there's no objective testing for fibromyalgia, therefore we're denying the claim. But objective testing doesn't even exist. So this is where we have to fight back and prove to the carrier, even though they already know this, that there's no such thing as an objective test to prove that somebody is disabled from something like fibromyalgia.
Right, and we were throwing around these terms, which we shouldn't assume that people know what they mean, but you have objective, which means a physical test like an X-ray, an MRI, a CAT scan, a nerve conduction study test, a brain scan, all of those things that are going to basically show undisputable evidence of a medical condition. And then you have what's considered subjective evidence, which is basically everything that a person says is wrong with them. So whatever they tell the doctors and whatever is documented in the notes. But the misconception that the disability carriers take advantage of is that there's no machine in the world that measures pain. There's absolutely no medical tool out there that says, regardless of what the objective evidence says, that this person should be in pain or not be in pain. Now, obviously, if we're looking at a broken femur or a broken arm or a broken hand and it's snapped in half on a X-ray or a scan, obviously you could say that person should be in pain. But there's still no meter saying what happens as soon as that person's casted or how their recovery is. And of course, we deal with herniated disc in the neck and the back and the mid back, all of those areas, all the neurological conditions. There's nothing out there to measure pain. So at the end of the day, no matter what objective evidence you have, when the disability carrier says the objective evidence does not support the subjective complaints, it's basically bullshit. I mean, there's no other way to call it. That's what it is. And what we need to do as lawyers is work with the doctors and work with the claimants to obtain strong medical evidence that specifically says why these complaints that a claimant's complaining of are reasonable and how those complaints limit the claimant from having the ability to do their job.
Right.
So, in terms of further understanding the disabling condition, why do the disability carriers always argue, and they're not necessarily wrong, that diagnosis doesn't equal disability? What does that mean, Rachel? And how do you deal with that and explain to claimants that just because you have a diagnosis, it doesn't mean you're going to automatically be eligible for disability?
Yeah, unfortunately, that is true in a lot of cases with the insurance carriers. They will often say, yes, we do agree that the claimant has the diagnosis. We're not going to deny that the claimant has MS or Parkinson's or may have a herniated disc in their back. But what they will say, and they often say this in their denial letters, is that just because you have multiple sclerosis doesn't mean you can't work. So this is always something that we have to work with the physicians with to try and make sure that we can prove, number one, that yes, there is a diagnosis, but that the restrictions and limitations that come along with multiple sclerosis are so severe that the claimant's no longer able to work. So the insurance carriers will often use that as an excuse as to why they're denying, and they'll say, well, our peer review physician has reviewed the medical records. They disagree with the claimant's doctors who think that their multiple sclerosis is disabling. They say, well, yes, you do have a diagnosis, but no, we disagree. We think you could work at your occupation on a full-time basis, no problem. So this is something that we deal with all the time, and we just have to work with the medical doctors, or we even have our own experts that we can bring in or send the clients for further testing in order to provide objective proof of that, not only is there a diagnosis, but that there's restrictions and limitations that come along with that diagnosis that are disabling.
And Rachel, the last topic is that often either people get approved on their own and then they call us because they're worried they're going to get cut off or they've been cut off, or you do an appeal for somebody, you win, and then they go back on claim. How important is the continued medical documentation of the condition? Again, along the theory that just because you got that diagnosis doesn't mean, and just because they approved you doesn't mean they're going to keep paying you. So how important is the continued medical documentation?
It's almost one of the most important things, Greg, because unfortunately, the claimants will have this false security that, oh, I got approved, they must think I'm disabled, I'm good to go, I don't have to go to the doctor for 6 months or maybe even a year. And that's one of the first things I explain to all of my clients is that please make sure that you have continuity of care. You must go to your doctors at least every 2 to 3 months, because if the insurance carriers see that there's a huge gap in treatment, number one, they take that opportunity to assume that you must be fine, because if you're not treating, then you're not sick. When a lot of my clients will say, well, my doctor says there's not much more they can do for me. I have this condition and it's permanent and there's no treatment. I say that doesn't matter. My advice to my clients always is, please make sure, even if your doctors have no more treatment for you, that you go in at least every 2 to 3 months, that you treat, you make sure you're telling your doctors everything that's going on with you. If you're in pain, you need to let them know. Don't be a superhero. It all needs to be in the records, because as soon as the carrier sees that, number one, the doctor isn't documenting any of your issues, or that you haven't been treating on a continual basis, they will cut you off again. And then you're back having to appeal the claim again, fighting to get back on, which takes some time. And it's a hardship on the claimants, because then they're not able to pay their bills and put food on their table.
Right. Well, those are some great pointers that you had there. The other thing important for people to know is that we have our own group of consulting experts in all of the medical specialties, from doing this throughout all of these years. And even if we have any questions about anything or the latest medical advances or medical treatments, we reach out to our own experts that are regularly available to us as well, which help guide us by reviewing the medical records and also telling us, here's some additional things that we think would be helpful, or here's what's wrong about what the insurance company's doctors are saying. So what I encourage people to do is, no matter what stage your claim's at, feel free to give myself or Rachel a call. We'll always offer you a free initial consultation and review of your claim. No matter where you live in the country, we're available to assist you. The other thing is, we encourage you to subscribe to our YouTube videos. We're regularly putting out videos that we hope you find helpful, such as these, and we're providing tips about how to handle your claim, tips about different medical conditions, and all kinds of information about your specific company. Also, always feel free to look up your disability insurance company on our website, and you'll find lots of information, including reviews, frequently asked questions, and lawsuit summaries from cases that we've handled, and the lawsuits around the country that aren't just our law firm, but we're tracking them all the time so that we always know the latest claims handling tactics and techniques that are being used by these disability insurance companies. So we appreciate you taking the time to watch this video, and we look forward to speaking with you should you need us in the future.